Tonight we're really grateful to welcome Kelly Askin to Holy Cross to talk about rape as a weapon of war. I suspect that few of us really consider often how frequently and systemically rape has been used in war to humiliate and subdue enemies, among other reasons. No one is better equipped than Kelly to discuss this topic with us. She's a senior legal officer for international justice with the Open Society Justice Initiative out of New York. For over 15 years, she served as an expert consultant and legal advisor to prosecutors, judges, and registries serving in international crimes tribunals in the former Yugoslavia, Rwanda, East Timor, Sierra Leone, and Cambodia. She's also worked on efforts to prosecute international crimes in criminal courts, including a mobile gender justice court in the Eastern Democratic Republic of Congo, where she's just returned. She's taught or served as a visiting scholar at Notre Dame Law School, American University's Washington College of Law, Harvard's Kennedy School of Government, Yale Law School, and Oxford University. She served as executive director of the International Criminal Justice Research Institute and the American University's War Crimes Research Office. She was a 2004-2005 Fulbright New Century Scholar in the Global Empowerment of Women. In 2005, she was named the prominent woman in international law by the American Society of International Law. Her books include War Crimes Against Women, Prosecution in International War Crimes Tribunals, and a 3-volume legal treatise, Women in International Human Rights Law. She's lectured in dozens of countries and has authored over 50 law review articles and book chapters. Please join me in welcoming Kelly Askin.
Can you hear me? Great. I don't get the opportunity that often to talk to undergrad students, so it's a real privilege to be here. And I don't get to talk to Americans very often for some reason. I seem to do most of my lectures overseas, and so it's really useful for me to have a sort of an engagement at a college. As Tom indicated, I focus primarily on international criminal law and international humanitarian law. So I'd like to share with you a little bit about how I got into that field, and then sort of take the steps that have come to allow me to work in this field. In 1993, I was a lawyer working on death penalty law and decided I wanted to get an advanced degree in international human rights law. I felt like I could do a lot more with my law degree if I did a area like human rights. And that year that I was thinking of getting an advanced degree, a doctorate in law, I had been following the war in the former Yugoslavia and had read about rape camps being set up during that conflict. And also during that same year in 1993, there was a World Conference on Human Rights in Vienna, and attending that conference, they brought women who had survived the rape camps in Bosnia, and the women were there, and they were very passionate. And it was also one of the first time, frankly, at a international human rights conference that women basically took over the agenda and forced violence against women onto the agenda. So it was due to being at that conference and meeting these women who had survived rape camps that I decided to focus my doctorate on how to prosecute war crimes against women. The United Nations had just set up an international war crimes tribunal for the former Yugoslavia. And so there was debate at that time, even at this conference on human rights, about whether rape was even a war crime. But to fully understand sort of how far we've come, I want to just take a quick historical look back. over mostly 200 years and then sort of the past 20 years, more specifically. When I started researching this topic, back in as early as 500 BC, there were codes of warfare in existence to protect combatants during armed conflict. There were wars had been raging on all continents, but they were governed by customs of war and religious codes. There wasn't anything codified as far as the laws of war. And up until the Middle Ages, during wartime, rape was the right of the victor. Women and girls were legitimate spoils of war. Domestically, of course, also during this time, girls were primarily considered, girls and women, property, first of their fathers, then their husbands, and possibly later in life their sons. I don't pretend that none of that still happens these days, because unfortunately in many countries women are still property, but in most of the world they have more rights. So the law of armed conflict only comes into play once an armed conflict exists. And this is important because, of course, you can do things in war that you can't do during so-called peacetime, and that includes killing people. In war, you're basically allowed to kill people within certain rules. So having an armed conflict exist is something to formally recognized as important. It was only in 1863 that it's called the Lieber Code. The U.S. Military looked at the customs of war and wanted to codify what the customs of war were into official code. And sort of that became the cornerstone of what future laws of war were based. That law of land warfare did specifically prohibit rape. In fact, it gave rape the maximum punishment, which was death. So back in, as far as 1863, we have a recognition that rape was a serious crime. So then the original Geneva Conventions, many of you have probably heard of Geneva Conventions in 1949 and others, where there's some that existed before the 49 Conventions in 1864, 1906, and 1929, and Hague Conventions. They were sort of based in large part upon this Lieber Code. Despite the fact that the Lieber Code and the customs of war had for centuries or at least at 1600s, prohibited wartime rape, it was virtually never enforced. So let's move to the 20th century. Fast forward. We have World War I first, which lasted from 1914 to 1918. During this war, over 20 million casualties, mostly civilian. And part of that was new technologies, airplanes and transportation and warships that you didn't have in many of the previous conflicts, and there hadn't been a world war prior to this time. In practice up until then, the victor was allowed to basically summarily execute known war criminals. So after World War I, a War Crimes Commission was set up, and it was the first effort to sort of establish some sort of criminality for war crimes. Nonetheless, despite a War Crimes Commission being set up and listing of 32 different offenses, including rape and enforced prostitution as war crimes, there was still widespread impunity. Instead, what then it was called the League of Nations, all they did was establish a pact that made supposedly war illegal, but war continued to flourish throughout the world. And then shortly thereafter, of course, World War II. Most of you have had been taught this, of course, in your history lessons. from 1939 to 1945, and there were unprecedented atrocities, including against, particularly Germany, against its own citizens. Millions of civilians, particularly Jews, were targeted, and over 70 million casualties during that war. The Allied victors of the war, the UK, France, England, and the USSR, met and decided to establish an international war crimes tribunals. So the Nuremberg, or IMT, or International Military Tribunal, was set up to prosecute crimes against peace, which was considered the supreme crime, war crimes and crimes against humanity. You will often hear, and it still amazes me, well, it doesn't amaze me today, that no rape wasn't prosecuted at Nuremberg. But there's, if you go through the 42 volumes of the transcripts from that trial, which I did when I was doing my doctoral thesis, you'll notice that there was many references to rape, sexual slavery, forced abortion, sexual mutilation, forced sterilization. It was in evidence at trial, and I consider it subsumed within the persecution count. So despite in one reason I think that people say there was no rape prosecuted at the Nuremberg Tribunal is in the I think it was over 700 page of the index. They didn't bother to index list rape. Under women, there was, maybe 2 sentences. That's all that it was warranted. And so most people thought that rape wasn't prosecuted at all at the Nuremberg trials, but like I said, I consider it was. One reason also is there were no women judges, no women prosecutors, no women defense counsels. And if you think about it, that's not very unusual. Even here in the United States, most law schools didn't even allow women at that time. So we've made a great deal of progress. But the fact that there were no women in senior positions, there were some as interpreters and things like that, but no in decision-making positions during the Nuremberg trials. And subsequent to the Nuremberg trials, there were, or just right afterwards, trials also held in the Far East called the Tokyo trials. Again, like the Nuremberg trials, rape wasn't listed officially in the statute. And again, the crime of essentially crimes against peace, aggression, was considered the supreme crime, and that was what they focused on. However, in these trials, 3 of the defendants were essentially convicted of rape crimes, among other crimes. And again, you will often hear that no rape crimes were prosecuted in Nuremberg or Tokyo, but if you actually read the judgment and read the transcripts of the trial, you'll find that they were. Many times they were prosecuted under sort of obscure names like inhumane treatment, ill treatment, failure to respect family honor and rights. But there's no doubt that it was prosecuted at Tokyo. These 2 trials have been criticized in many ways of being victors' justice. They were the victors of the war who held trials against the defeated foe. I'm not as critical when I read about that. Up until that time, they were allowed to summarily execute. So holding trials, and people were acquitted at most of these at these 2 tribunals. So they were considered in many ways fairly legitimate trials, although certainly there's been a lot of criticism, particularly of the Tokyo Tribunal. So we've had in a short period of time 2 world wars in the early 1900s. So shortly after the war, the countries came together and established the United Nations. as a result of World War I and II. In the over 70, 80, 90 million people who died in these two world wars. In Article 1 of the UN Charter, it's charged with the maintenance of international peace and security. Shortly thereafter, you have things like, in 1948, the Universal Declaration of Human Rights, including equality for all without distinction as to sex, the Genocide Convention in 1948, the 1949 Geneva Conventions, and in the Fourth Geneva Conventions, which many of you have heard about, it was the first time the conventions afforded protection to the civilian population instead of just the military. And it specifically, in one article, 27, prohibited rape and outrages to personal dignity. The subsequent additional protocols in 1977 also prohibited rape crimes. In not very strong language, but at least it's in there. They could have, by 1977, done a whole lot better than that. But they weren't considered like grave breaches, which were crimes, but nonetheless, you at least have the prohibitions in there. And yet, despite the fact that there was war crimes tribunals after World War II in Nuremberg and Tokyo, for nearly the next 50 years, war flourished around the world in mostly civil wars and during dictatorships, and tens of millions of people again died, and there was wide-scale impunity. And one reason I think it's important to talk to younger people is probably in your lifetime you don't remember the period of time when there was many sayings that you're more likely to be prosecuted if you murder one person than if you murder 10,000, and that was absolutely true. Between the war crimes trials after the Second World War and up until 1993, when they established the Yugoslav Tribunal, there was virtual impunity around the world for any atrocity crime during those nearly 50-year periods, and I think that's important to remember. And so early 1990, 1991, the war started in the former Yugoslavia, and there journalists, including for the first time, or maybe not the first time, but a lot more female war reporters reporting on these crimes. And there was the United Nations Security Council established a commission of experts to report on the crime and report back to them about what should be done if they found evidence of mass crimes. And of course, the Commission of Inquiry came back and said there were war crimes, crimes against humanity, and possibly genocide being committed on the territory of the former Yugoslavia. There were rape camps where women were held in detention until they were forcibly impregnated. So the Security Council for the first time set up an International War Crimes Tribunal and gave it authority to prosecute war crimes, crimes against humanity, and genocide. And in the crimes against humanity provision, it specifically mentioned rape, which was an enormous step forward at the time. It was set up, as many of you know, in The Hague, to be based in The Hague. Because the war was still ongoing, it was very difficult to set up in the territory where there was still fighting going on and continued for many other years. This was in 1993. And shortly thereafter, in 1994, during a period of 100 days, a genocide swept through Rwanda, and over 700,000 people were killed in mass slaughters and mass rapes in a 100-day period. The United Nations had just set up a tribunal for the former Yugoslavia. It had virtually no choice then to set up one for Rwanda. And I guess I should, I'm often asked why the Yugoslav Tribunal, because if it hadn't been the Yugoslav Tribunal, it would have never been a Rwanda tribunal. And if without these two tribunals, there would have never been an international criminal court and tribunals in other places. And what I believe is that it happened in Europe, and people remembered the promises of never again after the Holocaust, and mass atrocities were again happening on European soil. And so it's my belief that without the war in the former Yugoslavia, we would still be back where we were in the 1960s and the 1970s without any sort of accountability for atrocities committed around the world. The Yugoslav and Rwanda tribunals have gone a huge way to addressing gender crimes. And there's sort of a reason for this in many respects. There was a confluence of several things that were happening. First, you have the reports of mass rape in Bosnia, then the reports of mass rape in Rwanda, and the former Cumber women from World War II. Over 200 women forced into sexual slavery to the Japanese military during the war started coming forward after 50 years of silence and saying, us too, this happened to us during the war. So now you have a global phenomenon where there's Europe and Africa and Asia, women coming forward in massive numbers saying it happened to us too. You also have at the tribunals a handful of women in positions of power. I'll talk about some of the cases that have set the precedent of recognizing rape. But in every one of the first cases, one of the very few females sitting on the court was sitting on that case. And without their presence, again, I feel very sure that we would not have this jurisprudence and we would not be as advanced as we are today. There was also women as registrars, as investigators, as prosecutors, as interpreters, and others that were instrumental to recognizing gender crimes. We also had new technology during this period. As I mentioned, there was the World Conference on Human Rights in Vienna in 1993. We had the World Conference on Women's Rights in 1995, where women's groups from all over the world came together. And we had this marvelous new thing. It's not new to any of you. It's been in many of you your whole lifetime, but it was certainly new. I didn't have it till I was, in my 30s, this marvelous thing called email. And with that, people were able to communicate with other activists and other women's rights, people working on women's rights and scholars all over the world, and compare notes and have campaigns. And that's exactly what happened in the Yugoslav tribunal and in the Rwanda tribunal. So the first judgment, many of you hopefully have heard of Jean-Paul Akiusu, which was rendered in September 1998. At the time, the sole female judge on the court sat on that case, Navi Pillay. She is now the UN High Commissioner for Human Rights, but at the time she was the sole female judge from South Africa sitting on the Rwanda tribunal. In the midst, Jean-Paul Akiusu had not been charged with any rape crimes. He had been charged with war crimes and crimes against humanity and genocide for extermination and murder and torture, but no rape crimes. In the midst of trial, a woman testified about the rape of her 6-year-old daughter, and the next witness testified that she'd been raped and had witnessed many other rapes. So Judge Pillay, sitting on the bench, invited the prosecution to consider going back and investigating rape crimes, and if rape crimes were found and attributable to the defendant, to consider amending the indictment. And that's exactly what happened. The trial was adjourned. The prosecutor went back and investigated the crimes. Many human rights organizations, many scholars, many activists had sent to the tribunal prior to this time evidence of rape committed in Taba, and the prosecution essentially ignored it. But once the judge invited the prosecutor to go back, they essentially had no choice. They found the evidence of crimes, amended the indictment, Jean-Paul Accuse, who was ultimately convicted of many crimes, including rape, as a crime against humanity for the first time in history. The judgment recognized that the rape committed in Rwanda was a destruction of the spirit, of the will to live, and of life itself. That many women were killed after they were raped, but many more who were left alive intentionally because the perpetrators told them they were leaving them alive because they considered it worse than death. It was also the first time in history that rape was considered a part of the genocide. So this is the very first judgment coming out, and we have, in part because of women in positions of power and women's activists, one of the most groundbreaking judgments on women's rights in history. There's been a handful of other cases in the Rwanda Tribunal that have dealt with rape crimes. However, we have more acquittals and more dropped charges than we have convictions. And in large part, that's because women aren't paying attention and forcing the issue anymore versus when they first started and everybody was paying attention. Just a few months after the accused whose judgment was handed down in the Yugoslav tribunal, in the process of several months, several judgments came down, and that had also very important implications for gender crimes. The Celibici judgment in 1998, 4 were accused with various forms of sexual violence. Rape was not explicitly listed, but they were charged under inhuman treatment and cruel treatment, and just as many male sexual violence as female sexual violence, and that was very important. If you look at the indictment, you wouldn't know it was a rape crime case because it was charged under torture or more vague language. But when you read the judgment and when you follow the trial, the judges found that many women were raped by means of torture in order to intimidate them, to terrorize them, to discriminate against them because they were women. Males were subjected to inhuman treatment. And the judges said when 2 detainees had been forced to perform fellatio on each other, if the prosecutor had charged that as rape, they would have found rape. Shortly thereafter, the Frunzia case. Many people said the Frunzia case should never have been brought. It was essentially about the rape of one woman during one day of the conflict. Many activists were pushing the prosecutor to bring this case to say, yes, it is a serious crime to rape one person. It doesn't have to be systematic rape. It doesn't have to be rapes of tens of thousands to make it important to prosecute. So it was a trial of essentially 11 days. Again, it was not prosecuted as rape. It was prosecuted as torture and inhuman treatment. But again, the judges convicted the accused of sexual violence. And then the Kunoratz-Focha case was decided in February 2001, and this was the first case in history, the first case in the Yugoslav tribunal that prosecuted rape as a crime against humanity. And it was the first time that they prosecuted rape and enslavement for activity that essentially constituted sexual slavery. So in a very short period of time, we have several significant judgments coming out of war crimes tribunals recognizing rape as a war crime, a crime against humanity, and an instrument of genocide, and other forms of sexual violence. They're recognizing forced nudity. They're recognizing rape as an instrument, a form of torture, as a means of persecution. And they very specifically say in several of the judgments that the rape was used during the war as a tactic of war to intentionally affect the conflict. Huge progress in a very, very short period of time. So with these two tribunals up and running, and the trials showing evidence of many crimes. I mean, I'm focusing, of course, here on the gender-related crimes, but crimes of extermination and persecution and torture and rape. There's significant efforts to establish a permanent international criminal court. And during the negotiations for that court, again, women activists and people who've worked in the tribunals and who've seen these trials start coming together, and they put directly into the statute a lot of crimes that have never been in a war crimes tribunal, or never even recognized formally as a war crime or a crime against humanity or an international crime before, including sexual slavery, specifically mentioned, enforced sterilization, forced pregnancy, and other forms of sexual violence of comparable gravity. It also allows for gender-based persecution and trafficking in women and children. So huge progress in 1998 in Rome to establish the International Criminal Court. And there's, and also during this period, there's sort of a global shift between years and years and years of impunity to accountability. There's starting to be warlords and others are starting to recognize that they might be able to be hauled before an international court. So in fairly rapid succession, we have crimes committed in East Timor and a tribunal set up in East Timor, or a hybrid court, I should say. So a court with locals and internationals in East Timor. After a decade of civil war in Sierra Leone, they set up, the UN reached an agreement with the government of Sierra Leone to set up the Special Court for Sierra Leone, panels in Kosovo and Bosnia and Croatia to handle sort of so-called lesser war criminals that don't rise to the level of being prosecuted in international courts. The extraordinary chambers in the courts of Cambodia. There's such a change that people said, why should we prosecute just now current crimes? Let's go back. There was a genocide in Cambodia 30 years ago. Let's go prosecute that. So the UN and the government of Cambodia set up a tribunal to prosecute the Khmer Rouge crimes in the 1970s. And then in 2002, the ICC came into effect after 60th country ratified it. So we have now a decade of war crimes tribunals, and tens of thousands of perpetrators that can never come before these tribunals. It's just simply not possible to prosecute tens of thousands. So the UN is saying, so what do we do? So one of the core cornerstones of the International Criminal Court is this concept called complementarity. It's that the domestic courts have to investigate and prosecute crimes, including gender crimes. It's very difficult, of course, because after civil war, a breakdown of law and order, after chaos, sometimes wars have lasted 2 or 3 years, sometimes over a decade, sometimes 20 or 30 years. There's usually the legal system isn't functioning. And it's, as you can imagine, exceedingly difficult to prosecute people who many have held positions of power. In some wars, like Sierra Leone, the use of child soldiers is huge. They've abducted young kids, mostly boys, but girls too, to carry the water, men to fight, boys to fight. And they force them to commit horrible crimes. They put them on drugs often. They many times make them go back to their own community and kill somebody in their family. So what do you do when these young kids, 10, 12, 14, are given a gun, put on drugs, and they commit horrible crimes? You don't haul them before an international court, but the victims have become victimizers. They've committed massive rapes. They've committed, as you can imagine, these young teenage boys. So one of the structures that's been built is that after the war is over, they have to help rebuild communities. It's not just go and send no more and go home, but to help rebuild communities, build houses, build schools, build infrastructure, and help them go on with their life as well as the victims. But again, I think you may have heard like the Gacaca trials in Rwanda, sort of a form of community justice, because in Rwanda there were considered over 700,000 perpetrators. No justice system in the world can handle 700,000 or even 10,000 perpetrators in a very short period of time. And if you ignore the rule of law, as had been done for many decades and war continued, we know that impunity doesn't work. We are hoping that accountability will, at some point, the jury's, of course, still out. There's still wars going on all over the world. There is more accountability now than ever before, but it's not nearly enough. At the International Criminal Court, it's been now operating for over 11 years. They have open situations in northern Uganda and eastern Democratic Republic of Congo, in Darfur region of Sudan, in the Central African Republic, in Kenya, in Libya, Ivory Coast, and Mali. In all of those situations, of course, it's a real problem. They're all in Africa. In all the situations, not necessarily every accused, but in every situation except Mali, where we don't have any charges yet, because that was just last month, there have been charges for gender-related crimes, and that's huge. Rape and sexual slavery, and other gender crimes. Still, all these years later, we have less than probably 500 people who've been tried and prosecuted for these crimes. And again, we have tens of thousands, hundreds of thousands, some people even say millions of perpetrators. International courts or hybrid courts are expensive. It's hard to go investigate in crimes in other countries, especially when the war is still going on. The tribunal has no enforcement. It doesn't have its own police. The trials are sometimes long. The accused die, the judges die in the midst of trial, and many times they have to start over. They're completely reliant on states for cooperation, access, arrests, imprisonment. They don't have their own jails. They have to be put somewhere else. The challenges are enormous, and yet where we've come in 20 short years is nothing short of remarkable, both in justice more generally and in certainly recognizing. When I started, I think I said, this back 20 years ago, there was debate whether rape was a war crime. Now we have rape as a war crime, a crime against humanity, an instrument of genocide, a form of torture, a means of persecution, sexual slavery, enforced sterilization. Many forms of sexual violence is recognized. And then more recently, of course, the UN Security Council has made several resolutions focused on women in war. Its first ever Security Council resolution on women in war was in 1992, expressing outrage over the massive, organized, and systematic rape of women in Bosnia. But in the last 13 years, most people have heard of Resolution 1325 on women, peace, and security. And they've recognized very specifically these Security Council resolutions that sexual violence is a threat to international peace and security, and that impunity is a threat to international peace and security. Huge, huge. Security Council Resolution 1820 specifically notes that women and girls are particularly targeted by the use of sexual violence, including as a tactic of war to humiliate, dominate, instill fear in, disperse, or forcibly relocate civilian members of a community or ethnic group. To give sort of how this happens, if you go into in Bosnia, for instance, if the military took over one village, publicly gang raped 6 or 7 young girls, got to the next village, everybody would have fled. There's rape destroys communities. It destroys whole families. It doesn't just harm the individual victim. Increasingly, it's used strategically to humiliate, to demoralize, to destroy, to terrorize. I cannot argue with that. The use of, even though it wasn't going into a village to terrorize, the use of the comfort women in over 200,000 comfort women in World War II by the Japanese military was a strategy of war because it impacted the armed conflict. They felt like they had women held for sexual use to relieve their soldiers, so they didn't, and they were held forcibly for their own sexual gratification of their own soldiers. In part, they did it, they said, so that in occupied territories where they were trying to establish good relations, their soldiers didn't go out and rape, so they snatched women off the streets, or they told them, women and girls, that they were getting a job in a bar or a restaurant or something, and then of course held them in sexual slavery. I consider that also intentionally using to impact the conflict, even though it's sort of the opposite of how it's usually used to terrorize. And more recently, we're seeing a lot more of male-based sexual violence, certainly in Libya and Syria, in Chechnya, and in Sudan and Uganda. I think it's more than just being reported more. I think that part of the shame and stigma attached to sexual violence has made it a powerful weapon of war. So I rarely talk about this issue without urging that we have to reverse that shame and stigma. We have to take this shame and stigma off the victims, off the survivors of these crimes, and put them on the perpetrators. We have to, it can't be a boys will be boys attitude, or this is a byproduct of war, or a inevitable consequence of war. It's got to be the people who commit these crimes are weak and cowardly. We have to reverse the shame and stigma to take away its power. There should be no more shame and stigma to a woman or a male who's raped than it should be if they've been stabbed in the arm or shot in the leg. It's become, I think, recognized sort of globally now that that women are targeted more and more. I mean, many of the peacekeepers say, and I believe it to be true, that it's more dangerous to be a woman in war now than it is to be an armed soldier. There's many reasons for this. Of course, sexual violence is about one of the most private parts of people's bodies. It makes people uncomfortable to talk about it, makes people uncomfortable to investigate. Women or boys don't want to talk about something committed about the most private part of their body to a strange investigator who's coming to talk to them. And again, the shame and stigma often, and the domestic court system as well as international courts somehow still seem to often blame the victims of sexual violence far, far, far more than they do victims of other forms of violence. War has changed. This is due to technology, weapons of mass destruction, but it's, I think that attitudes are slowly changing. I spend a great deal of my time in Eastern Congo, which is considered by the UN the rape capital of the world, and I worked with to set up a mobile gender justice court that goes to very remote areas, provides justice to places otherwise without access. And I've seen there and many other places, but there probably more vividly because it's been such a short period of time. I've only been going there for 4 years, working with this court, and seen a drastic change in attitude. When I first suggested setting up a gender justice court, everybody, even the human rights and the UN, said, good grief, they've got so many problems here. That's the last thing. They need, there's so many problems, that's the last thing you should do. And now people recognize what a horrific crime it is, how devastating it is to not only the victims, but to the families and the communities, and that the victimized population is far beyond the victim, and it is one of the most serious crimes committable. People were finally starting to get that. Many of the judges who did not want to sit on these courts are saying, this is, when I hear these stories, it's horrific. So I do think it's possible to slowly change attitudes. Just leave you with one, the most vivid example I can give of watching an attitude change was back in 1993, 1994, when I was working with some of the former comfort women who were coming forward for the first time after 50 years to talk about their sexual slavery. And when I first met with them, they hung their head and they whispered, and they clearly felt like an outcast and a pariah. And when colleagues and I, met with them and said, to have survived what you did, you're strong and resilient and courageous. And as they slowly came to recognize that they were not just victims, but survivors, we held a public forum a few years in 2000, and some of these same women who had been so ashamed stood up before we brought in real judges from the tribunals and human rights leaders, and heard testimony of what happened to them, and stood before a crowd of over 2,000, these same women in their 70s and 80s, and stood up and were proud to say what they survived. And that was instrumental to, I think, a lot of the work that I've done over the past 15 years after that, is watching their courage and learning to treat people as survivors and not as victims, and that we all have to change our mindsets as sisters and neighbors of if you can imagine how women are still treated, and men who are victims of sexual violence domestically, is 10 times worse. Its magnitude is magnified in war, and we have to change that. I guess I'll leave it there unless you and open it up to questions if you have any on this light topic. In Rwanda, I don't know the numbers of statistics, but I do know in Rwanda that they even took prisoners who had HIV and released them and forced them to go rape women and leave them alive, so that they would go back and have sex with their husbands, or and destroy whole communities. Sort of I mean, I haven't gotten into sort of the fact that women are the reproducers is also one reason they're targeted for sexual violence. But there have been many, many, many instances, not only in Africa, but in Asia and other places. But I don't know the statistics where they've intentionally used people who did have HIV to rape. And it's been heartbreaking. I guess I've worked on that more in Rwanda than anywhere else. When the victims or survivors, when I said earlier that there have been more acquittals than dropped charges in the Rwanda tribunal than convictions, part of it is because many of the women have died of AIDS. Many of them are bitter because the defendants who may have AIDS get treatment because they're in the UN, of course, is forced to give them shelter and food and water and medicine. And the victims say, why should they live these cushy lives when we're living on a mud floor and don't have access to the antivirals? And they resent the fact that defendants have basic human rights respected in these courts, and they do get access to the medicine that they don't have. But I haven't spent as much time looking at that as many do, and I think it's a really important area, but it's just not an area that I have focused on as much as I think is important. One of the few places there is an international criminal court, of course, International Criminal Court, but it's a court of last resort. So if there's a genuine willingness and ability to prosecute or investigate or prosecute domestically, the ICC does not have jurisdiction. And also, the U.S., Russia, and China are not state parties to the ICC, so the only way a national of one of those countries could come before the court is if there were a Security Council referral. There will never be a Security Council referral because they have veto power. So essentially, powerful countries, unfortunately, do have impunity, I would say. Now, I mean, there have been cases before regional human rights courts, but again, most of those are not for individual criminal responsibility. The individual criminal responsibility are the international criminal courts, and most of the powerful nations are not parties. It's a very frustrating, a lot of critics criticize the courts for that. To me, I just say, should we not do anything in Congo or Uganda or Sudan or anywhere else just simply because there are double standards? I don't think so. Some people do. There have been efforts to try them, sometimes domestically, but the fact of the matter is, international justice is still very young. It's only 20 years old. It's going to be at least another 20 or 30 years, I think, before you have powerful people charged before these courts. Having said that, there's still, Charles Taylor, nobody thought Charles Taylor would be able to be hauled before the Special Court of Sierra Leone, and he was convicted last year and sentenced to 50 years in prison. Al-Bashir, the president of Sudan, has been indicted by the International Criminal Court. Maybe they'll never get jurisdiction over him, but he's no longer free to travel. He's had his assets frozen. He's considered a pariah many times when he tries to do something at the UN. Suddenly he'll find that everybody sitting around him has decided not to come to lunch that day. So nobody thought we'd get Slobodan Milosevic before the Yugoslav tribunal. So we have made progress when people said it wasn't possible. I think eventually you will see Americans or Chinese or Russians or others from powerful nations prosecuted, but it's not going to be soon. What you see a lot in Latin America now, many war crimes trials of formerly powerful leaders, crimes against humanity, war crime, and genocide trials in many places of Latin America, but it's taken 20 or 30 years. And many of those are domestic trials. Once they lose their immunity or once the country decides they're not going to protect them, we have gotten very powerful people that 20 years ago I'd have never thought. But yeah, there's no question it's a double standard in many respects. But unless it rises to the level of war crime, crime against humanity, or genocide, these tortures wouldn't come before these courts anyway. They would potentially be a state action before a regional human rights body. I mean, there's UN minimum standards for the treatment of prisoners. They have to have enough space, certain amount of space. They have food and meals, exercise. Certain minimum standards that even domestic courts are supposed to uphold. One reason the U.S. hasn't agreed to take any of the people convicted before any of these tribunals is sometimes our domestic prisons don't meet minimum UN standards of treatment. There's no way the UN can violate human rights for defendants, though. So victims don't understand that, and I appreciate that. But as a human rights lawyer, I believe that minimum standards are very important for humane treatment of everybody, regardless if you're accused of being a genocidaire or others. But yeah, it's painful to the victims, and rightly so. I guess one thing I should add, it's been interesting to me to watch recently, is that as more information comes out about male rape in Libya and Syria particularly, Muammar Gaddafi was raped just before he was killed, and that was videotaped. Then suddenly, some people who've been arguing with me for years that rape isn't intended to demoralize or to terrorize, they sort of get it now that it's against men, and I find that so frustrating. But at least, they get it, but they only get it when it's against men. They don't still get it when it's against females. And so again, I think this is another area, baby steps. It's attitudes and it's information, and I think that we'll get there. But there is huge need of continued progress and huge effort, because we're not even close to even adequate, despite the remarkable progress we've made.